Señoras y señores, muy buenas tardes. En el aula magna de la Facultad de Derecho de la Universidad de Buenos Aires, damos comienzo al acto en el que se hará entrega del diploma que acredita al doctor Ronald Dworkin como Doctor Honoris Causa de la Universidad de Buenos Aires, mediante resolución del Consejo Superior número 2918/2011. Preside este acto la señora decana de la Facultad de Derecho, doctora Mónica Pinto. La acompañan en el estrado, junto a nuestro ilustre homenajeado, el licenciado Carlos Masvélez, secretario general de la Universidad de Buenos Aires. Nos acompañan también autoridades de la Universidad de Buenos Aires, docentes, no docentes, estudiantes e invitados especiales. A continuación, invitamos a subir al escenario al secretario de Investigación de la Facultad de Derecho, doctor Marcelo Alegre, quien formulará la laudatio académica del doctor Ronald Dworkin.
Decana Mónica Pinto, profesor Ronald Dworkin, señora Irene Brendel, amigas y amigos. Con este doctorado honorífico, la Universidad de Buenos Aires homenajea al profesor Ronald Dworkin por sus contribuciones sin paralelo al universo de las ideas, a lo largo de un rango enorme de temas y áreas del conocimiento. Este espectro amplísimo incluye la filosofía ética, moral, jurídica y política, la teoría de la interpretación, el derecho constitucional, la teoría de la democracia, el derecho de los derechos humanos, el derecho internacional, como lo ejemplifica la conferencia que dictará el profesor Dworkin en unos minutos, y la lista continúa creciendo. Por ejemplo, en unas semanas el profesor Dworkin dictará en Suiza una conferencia Albert Einstein, en la que expondrá sobre la difícil relación de la física con lo contingente y sobre el fin del empirismo. Ronald Dworkin estudió en Harvard, Yale y Oxford. Fue profesor Holfeld en la Escuela de Derecho de Yale, profesor de Filosofía del Derecho y Fellow en Oxford, y profesor Quien de Filosofía del Derecho en el University College de Londres. En la Universidad de Nueva York es profesor de Derecho desde 1975 y profesor Frank Henry Sommer desde 1994. Ha recibido, entre otras distinciones, el premio Nicholas Luhmann en Ciencias de la Universidad de Bielefeld, la Friendly Medal del Practicing Law Institute, la Jefferson Medal de la Universidad de Virginia y el premio Holberg en Humanidades del Reino de Noruega. Entre sus numerosos libros se destacan Los derechos en serio, de 1977, Una cuestión de principios, de 1985, El imperio del derecho, de 1986, El dominio de la vida, de 1993, El derecho de la libertad, de 1996, Virtud soberana, del año 2000, La justicia en toga, de 2006, Es posible aquí la democracia, de 2006, La falange de la Corte Suprema, de 2008, y La justicia para erizos, de este año. Al mismo tiempo, la entrega de este diploma es una buena ocasión para reflexionar sobre la inmensa pertinencia de las ideas y argumentos del profesor Dworkin, en particular respecto de nuestro país. Al fin de cuentas, este doctorado es, antes que nada, una forma de agradecimiento por los aportes del profesor Dworkin al mejoramiento y al progreso del derecho y de su enseñanza en la Argentina. Cuando se recuperó la democracia, en 1983, muchos textos de Dworkin ya eran conocidos en nuestro medio. Desde entonces, sus ideas iluminaron debates y avances cruciales para nuestras libertades. Una de las primeras tareas de la democracia, a cargo de sus jueces, era la de construir rápidamente una nueva jurisprudencia constitucional que reemplazara las concepciones jurídicas autoritarias oscurantistas y represivas, vigentes luego de medio siglo de inestabilidad constitucional. Un pilar de esa empresa era la necesidad de arraigar una noción robusta de los derechos. Hasta entonces, uno de los dogmas simplistas dominantes afirmaba que en un eventual conflicto entre los intereses generales y un derecho individual debían primar los intereses generales. La crítica de Dworkin al utilitarismo, en paralelo a la de John Rawls, enriqueció una comprensión radicalmente diferente de los derechos. Ellos se desprenden de la exigencia de que el Estado exhiba igual respeto y consideración hacia aquellos de quienes reclama obediencia. Los derechos son cartas de triunfo frente a las consideraciones políticas generales, y su respeto a veces implicará la frustración de algunas preferencias mayoritarias. La democracia, aprendimos de Dworkin, no puede reducirse a la mera regla de la mayoría. Esta comprensión robusta de los derechos se plasmó en fallos como Basterrica o Cejián. En Basterrica, la Corte Suprema declaró la inconstitucionalidad de la punición de la tenencia de drogas para consumo personal. Este precedente fue dejado de lado por la Corte de los 90. Cuando 2 décadas más tarde la Corte actual reivindicó a Basterrica, se basó en escritos del profesor Dworkin para afirmar, citándolo: el Estado tiene el deber de tratar a todos sus habitantes con igual consideración y respeto, y la preferencia general de la gente por una política no puede reemplazar a las preferencias personales de un individuo. En el fallo Cejián, que declaró la inconstitucionalidad de la prohibición de contraer segundas nupcias a las personas separadas, el juez Petracchi se basó en la obra del profesor Dworkin para sostener que, cito, la primera parte de nuestra Constitución se encuentra destinada a proteger a los ciudadanos, individualmente y en grupo, contra ciertas decisiones que podría querer tomar una mayoría, aun cuando ésta actuase siguiendo lo que para ella es el interés general o común. En la causa González de Delgado, la Corte avaló la decisión de la Universidad de Córdoba de permitir la inscripción de mujeres en el Colegio Montserrat de Córdoba. Frente al agravio de los padres que se oponían a este cambio y acusaban a los jueces de legislar, el juez Petracchi formuló una extensa cita del libro Una cuestión de principio, en la que el profesor Dworkin cuestiona la pretensión de apoliticidad de la lectura conservadora y originalista de la Constitución. La cita concluye así: basarse en la teoría política no es una corrupción de la interpretación, es parte de lo que la interpretación requiere. Otra misión de la democracia naciente era la de restaurar una noción básica de igualdad ante la ley. Esa tarea hacía inaceptable la impunidad de los responsables de las atrocidades de la dictadura. En 1985, nuestro hoy homenajeado estuvo en Buenos Aires y asistió a algunas audiencias del histórico juicio a las juntas, seguido contra los comandantes de las Fuerzas Armadas, varios de ellos expresidentes de facto, en un contexto de amenazas al gobierno democrático y bajo la acechanza de un aparato represivo aún intacto. Sus impresiones, junto a un lúcido análisis de la historia de la violencia en la Argentina del siglo XX y a una vívida defensa de la necesidad de juzgar y castigar a los responsables de las atrocidades, fue publicado como el prólogo a la versión en inglés del Nunca Más, bajo el expresivo título Crónica desde el infierno. Permítanme leer algunas pocas líneas como pintura del horror en el que vivimos durante tanto tiempo y como una apelación tan vigente hoy como hace 3 décadas a que exhibamos la mayor de las intransigencias frente a la práctica de la tortura y la desaparición. Escribió Dworkin: el juicio se llevó a cabo en una sala sombría y con paneles negros, en la sede del tribunal en el centro de Buenos Aires. Los escalofriantes detalles serán posteriormente difundidos a la nación en los diarios, periódicos y la televisión. Asistí a una de las audiencias con un grupo de filósofos y abogados británicos y estadounidenses con los que había ido a Buenos Aires a discutir sobre derechos humanos y civiles con miembros del gobierno de Alfonsín. En un solo día escuchamos 2 testimonios que confirmaron la arbitrariedad, la criminalidad absoluta y la violencia sexual presentes en el mundo que los torturadores habían creado. Una joven declaró que después de haber sufrido durante meses torturas y vendajes constantes en sus ojos, se le permitió, al igual que a otros en su grupo, higienizarse para recibir una visita del general Galtieri, que por ese entonces era comandante del ejército en el distrito local. Galtieri le preguntó a la joven si sabía quién era él y si comprendía el poder absoluto que tenía sobre ella. «Si yo digo que vivís, vivís», comenzó, «y si digo que morís, morís. Como resulta que tenés el mismo nombre de pila que mi hija, resulta que vivís». Otra chica declaró que uno de los jóvenes oficiales que la había torturado le preguntó si podía escribirle después que lo asignaran a otras tareas. «Me gusta mantenerme en contacto con todas mis chicas», le dijo, y durante años le mandó a la chica tarjetas navideñas. Su análisis de la sentencia resulta de enorme y vigente interés jurídico. Continuaba Dworkin. «La política del tribunal de hacer distinciones entre los acusados, absolviendo a 4 y dictando sentencias menos severas para otros, fue valiosa en varios sentidos. Primero, mostró al tribunal como un órgano independiente del gobierno y de los fiscales, que habían exigido sentencias mucho más graves, y en ese sentido reforzó el carácter del juicio como un ejercicio del debido proceso de la ley, más que como una venganza política. También evitó cualquier sugerencia de que no podía haber grados de culpa para los delitos contra la humanidad, que quienes habían cometido atrocidades podían cometer otras sin temor alguno a ser castigados en el futuro». Y concluía Dworkin tomando, como siempre, una posición clara y fuerte, que se volvería muy relevante en los años futuros para la Argentina, pero también para Estados Unidos y el mundo entero. Cito: «Debemos esperar que el gobierno de Alfonsín acepte el riesgo y procese a cualquiera de quien pueda probarse que torturó o mató a civiles, aún siguiendo órdenes, aún si resultara que solo un pequeño número de personas fuese condenado. El mundo necesita un tabú sobre la tortura, necesita una creencia indudable y arraigada de que la tortura es criminal en cualquier circunstancia, que nunca puede haber una justificación o excusa para esa práctica, que todo aquel que la inflige comete un crimen contra la humanidad». Fin de la cita. Sus discusiones sobre la objetividad en la moral y en el derecho son un antídoto poderoso contra una de las distracciones más perniciosas en el pensamiento contemporáneo: el subjetivismo, la noción de que ni las afirmaciones morales ni las jurídicas son susceptibles de ser verdaderas o falsas. El profesor Dworkin, a lo largo de más de 4 décadas, ha venido explicando la inconsistencia del escepticismo externo o arquimédico, que asume incorrectamente que, en sus palabras, cito, «existen preguntas filosóficamente importantes sobre los valores que no se responden con juicios de valor». El profesor Dworkin también ha argumentado extensamente en contra del llamado pluralismo axiológico, la visión de que los valores fundamentales son radicalmente incompatibles. Esta visión puede dar lugar a cierto conformismo intelectual que lleve a juristas y pensadores políticos a abandonar prematuramente el desafío de armonizar los valores más importantes. Este conformismo vulnera la exigencia de integridad, que requiere que nos esforcemos en interpretar cada valor a la luz de los demás. Nos exige, por ejemplo, que entendamos a la igualdad a través del prisma de la libertad y viceversa. Dworkin nos propone que busquemos consistencia y respaldo mutuo entre nuestras convicciones, y esta búsqueda de coherencia debe guiarnos incluso entre diversos dominios, como la ética, el derecho y la política. Por ejemplo, debemos responder a la pregunta sobre nuestro florecimiento y crecimiento personal, pensando al mismo tiempo en nuestras obligaciones con los demás. La clásica dicotomía entre autointerés y altruismo, propone Dworkin, debe dejar paso a la noción de dignidad. La dignidad respalda nuestras aspiraciones personales y también justifica nuestras ambiciones, pero al mismo tiempo requiere de un contexto igualitario. Si la cancha está inclinada, mi triunfo no es digno. Por injusta, mi victoria no agrega nada a mi crecimiento personal. Las ideas de nuestro homenajeado ayudan a iluminar otros debates actuales, como el de las debilidades de nuestras democracias. En nuestro país, tanto como en el suyo, la calidad democrática exige, por un lado, eliminar la influencia del dinero en la política y, por otro, asignar un peso mayor a las ideas. Su aspiración es que el peso que hoy tienen los intereses económicos en el sistema político lo ocupen las ideas. Dworkin ha escrito extensamente denunciando los retrocesos en la protección de la arena democrática frente a las presiones económicas. Las contribuciones de Dworkin también son importantes para el mejoramiento de la actividad de los jueces. Su teoría de la interpretación judicial apela a la responsabilidad de los jueces en hacer su aporte para mejorar el derecho. Cuando los jueces enfrentan los casos difíciles, como aquellos en los que se discute el alcance de alguna cláusula constitucional abstracta, tienen una responsabilidad ineludible: proveer la mejor solución al caso que enfrentan. Ellos no pueden escaparse de esa responsabilidad bajo pretexto de ejercer una supuesta discreción judicial, completando, entre comillas, el derecho por medio de un acto de legislación judicial no sometido a estándar alguno. Tampoco cumplen con su responsabilidad si resuelven esos casos por medio de algún artificio supuestamente neutral, como la apelación al literalismo o a la intención original del legislador o del constituyente. Sus textos también echan luz sobre temas complejos como el del aborto, respaldando a la amplia mayoría que de uno u otro lado del debate desea una aguda disminución en el número de abortos, pero al mismo tiempo reconoce que el derecho penal ha fracasado como herramienta para lograr ese objetivo. El profesor Dworkin ha mostrado con elocuencia cómo la decisión de abortar pertenece a la esfera más sagrada de la autonomía individual, la de las decisiones éticas profundas, que el Estado no puede usurpar sin ofender la dignidad de las mujeres. Las concepciones de Dworkin son relevantes también en materia de derechos sociales y económicos. Su concepción de la igualdad de recursos es aún más pertinente jurídicamente en la Argentina que en los Estados Unidos, donde todavía solo una minoría de juristas lee derechos sociales y económicos en su Constitución. En nuestro país, en cambio, la Constitución expresamente reconoce estos derechos, consagra repetidamente la igualdad real de oportunidades y garantiza el acceso universal y gratuito a la educación y a la salud. La noción dworkiniana de la igualdad de recursos es una contribución muy fértil para la reconstrucción teórica de nuestro marco constitucional. Un Estado democrático constitucional debe garantizar a sus habitantes iguales recursos para que ellas y ellos puedan moldear sus destinos y enfrentar las incertidumbres de la vida, incluyendo las referidas a la salud y a la dotación genética. Los derechos sociales y económicos, pues, no son la consecuencia de una mera buena voluntad humanitaria, ni derivan de una aspiración por maximizar el bienestar agregado. Ellos son un requerimiento en el plano material de la igualdad moral de las personas. Del mismo modo, las reflexiones de Dworkin sobre la desobediencia civil son especialmente útiles para ayudarnos a eludir las reacciones facilistas frente a fenómenos complejos, como las acciones de protesta que llevan a cabo quienes objetan la validez legal de una norma o de un curso de acción estatal. También sus escritos sobre las acciones afirmativas han mostrado que éstas no violan derechos y que constituyen, en cambio, una herramienta legítima y eficaz para lograr el objetivo de la diversidad. En nuestra facultad, igual que en buena parte del mundo, sus obras lideraron la renovación de las ideas filosóficas, en nuestro caso, contribuyendo a la liberación del pensamiento filosófico de los límites marcados por la disputa entre el positivismo lógico y el justnaturalismo tomista. Quienes enseñamos Derecho, también agradecemos al profesor Dworkin por la elocuencia y claridad de su prosa y por ayudar a presentar al derecho como una provincia de la moral, o en otras palabras, a mostrar la estrecha continuidad entre la argumentación jurídica y la filosófica. Su crítica al positivismo jurídico ha puesto en el centro de la consideración los problemas que enfrentan quienes aspiran a identificar en forma no valorativa las soluciones jurídicas. Otra de las virtudes de nuestro homenajeado es su profundo compromiso con la deliberación pública. A lo largo del último medio siglo ha escrito en los medios de prensa en contra de la guerra de Vietnam, ha defendido la libertad de expresión, ha bregado por un sistema igualitario y universal de salud y por un sistema impositivo más progresista, ha demolido los argumentos expuestos por la mayoría conservadora de la Corte Suprema de su país, que entronizó torcidamente a George Bush en la presidencia en el año 2000, o que restringió las regulaciones financieras en las campañas electorales, o que hizo más borrosos los límites entre religión y Estado. Ha cuestionado a Guantánamo y los tribunales militares establecidos para juzgar a sospechosos de terrorismo, etcétera, etcétera, etcétera. Por último, estamos muy agradecidos y felices de escucharlo exponer sus ideas hoy y de poder discutir sobre su último libro mañana. A propósito, el profesor Dworkin tiene otra virtud, la de responder incansable y meticulosamente las críticas y observaciones que sus escritos generan. Su legendario coloquio, codirigido con Thomas Nagel y a veces con Jürgen Habermas y Jeremy Waldron, es una muestra de lo más elevado de la discusión académica. Mucho debemos aprender de la actitud con la que Dworkin encara los trabajos de los demás, poniéndolos siempre en su mejor luz, antes de, por supuesto, desintegrarlos. Si se conformara un club internacional de refutadores de Dworkin, su membresía sería muy numerosa y el capítulo argentino del club también dispondría de muchos socios. Refutadoras y refutadores de Dworkin, mañana a las 11 en el Salón Rojo tendrán una nueva oportunidad para hacerse oír. Profesor Ronald Dworkin, con este doctorado honorífico, la Universidad de Buenos Aires hace un humilde pero sincero reconocimiento a uno de los filósofos más relevantes de nuestro tiempo, al jurista innovador y al ciudadano comprometido. Agradecemos pues su aporte para mejorar la calidad de los estudios del derecho, para entender las exigencias políticas y económicas de la igualdad, para enriquecer la argumentación de jueces y gobernantes y para profundizar la democracia. Me permito, con mis disculpas, unas últimas palabras en inglés que intentan sintetizar las razones de este doctorado honorífico. Dear Professor Dworkin, we are honored by your presence here tonight. Your ideas express the best hopes of our still young democracy. Your arguments are an unparalleled source of inspiration to improve our law, our teaching, and our scholarship. Your integrity as a public citizen is an example for our intellectuals and our youth to follow. With this honorary degree, the University of Buenos Aires recognizes and celebrates your gigantic contribution to the world of ideas. We are thrilled to be able to listen to you tonight and tomorrow. We all hope you and Irene will enjoy your stay in Buenos Aires. With this diploma, we say, as citizens, thank you for helping us to better think about our democracy. As lawyers, we say thank you for helping us to understand the demands of equality. And finally, as professors, we say thank you for helping us to improve the teaching of the law as the privileged province of justice. Muchas gracias.
Seguidamente, la decana de la Facultad de Derecho, doctora Mónica Pinto, hará entrega del diploma y la medalla de la Universidad de Buenos Aires que acredita como doctor honoris causa al doctor Ronald Dworkin. Thank you so much.
I am
Thank
so-
you so much. Thank you, thank you. We are very proud.
it's lovely.
The coin of the university.
Thank you. Thank you. Well, very nice.
She will introduce you in a few minutes. A continuación, el doctor honoris causa de esta universidad, Dr. Ronald Dworkin, disertará sobre una nueva filosofía para el derecho internacional.
No, ya está, insistí.
Hay que resistir.
Sí, sí, ya.
Dean, Secretary General, professors, students, friends, I thank you from the bottom of my heart for this honor. By awarding me a degree of this university, you make me one of you, and I'm proud to join you, and I thank you. As for Professor Allegre's summary of my work, may I say, I never liked my ideas so much as when I heard him describe them. So I'm very grateful. That was quite wonderful. I wanted this evening to say a little bit about international law. I represent a citizen of one country. I come here. You are part of the international community, more responsive and aware of your role in that respect than most citizens of my country are. And international law, I believe, will become a matter of increasing importance. Indeed, perhaps one day of paramount importance to the survival of our civilizations. When I was first taught about international law, it was in Oxford, as you can gather, almost 100 years ago. And at that time, the most important question that my teachers addressed was, is there any such thing as international law? That was a question bound to appear on the examination papers, so we paid a lot of attention to it. That doesn't seem any longer to be a pertinent question. All international lawyers, all statesmen, all ministers of state seem to assume that there is international law and that, for example, the statutes and edicts of the United Nations are part of international law. But old philosophical puzzles are never solved. They simply go out of fashion. And the worries that prompted the question, is there any such thing as international law, are still vivid. The great importance, to my mind, in thinking about what international law properly understood really is, comes when we must interpret what we say is international law. We must interpret it and apply it to the most politically charged issues. For example, just now, there is much debate about the status under the laws of war and under the Geneva Conventions of international terrorist organizations that don't occupy any territory and whose soldiers do not wear uniforms. The question arises, are we at war with Al-Qaeda Or is this a police action directed against criminals? Does international law require that the prisoners America holds in Guantanamo Bay should be accorded the privileges of the Geneva Conventions, or are they really to be understood, as President Bush called them, as enemy combatants not entitled to the status of enemy soldiers? The United States has, in recent times, sent unmanned bombs over many thousands of miles, directed by pilots, as they call themselves, in Texas, to kill individual members of what it takes to be, of what our government takes to be, members of terrorist organizations. And the question of whether what we do with drones, as they're called, is a vivid question of international law, much debated. I'm going to talk this evening more about another matter of interpretation, which is very much alive, and that is the question whether NATO's intervention in Kosovo without Security Council backing was a violation of the United Nations Charter, particularly Article 2.4, which I have someplace, as it turns out. Article 2.4, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Is intervention in Kosovo designed to put a halt to genocide? Should we count that as a violation of the prohibition against an attack on territorial integrity or political independence? Very important issue. Came up, I think, again in Libya, though under very different circumstances. International lawyers divide about the question how to answer this. One very eminent colleague of mine at NYU, sadly recently dead, Thomas Frank, said the intervention in Kosovo was illegal. It was an example of international civil disobedience. It was morally required, though legally forbidden. That is a very dangerous idea. International law is nascent at the present time, struggling for rebirth, and to announce that morality is a trump over law in circumstances such as this, very dangerous idea. And that makes the question of interpretation all the more vivid. When I was asked as a student, is there any such thing as international law? Legal positivism, which Marcello mentioned, was still the dominant theory of international law, and that made the question an obvious one, and indeed a negative answer seemed plausible. Legal positivism at that time was taken to come to the views of John Austin, who held that law exists only when there is an uncommanded commander, someone indisputably in charge, and law are the commands that the undisputed sovereign issues. In international law, there is no undisputed sovereign wholly in charge. And therefore, if you adopt the Austinian theory, the Austinian version of positivism, then there is no international law. Just about the time that I considered the matter, Herbert Hart had developed a more sophisticated version of positivism, according to which law exists even when there is no uncommanded commander. Law exists when the officials of a political community, or the vast bulk of them, have accepted just as a matter of convention, a certain way of identifying law, of identifying how law is made, how law is enforced, how law is recognized. He called that rule, that fundamental rule accepted as a matter of convention, a rule of recognition. And then in his most famous book, when he came to talk about international law, he said, it is obvious that there is no rule of recognition in the international community. But then, as a kind of surprise, he said, however, that doesn't decide the question whether international law is law. One would have thought, given his definition, that it did decide the question. But then he said, perhaps it is theoretically or practically useful to count international law as a kind of law. It's worth pausing a moment, I think, to understand that in saying that, this great positivist, Professor Hart, was bringing together two different concepts of law, a sociological sense of law, the sense we use when we ask ourselves, would it be a good idea to count the internal rules of great international corporations as constituting a legal system? Well, we would say, yes, if that's helpful, if that throws light on the general nature of law, that might be a good idea, or it might just lead to confusion. That I would call the sociological concept of law. There's another concept of law. It's the concept you use in this building. It's the concept that your professors adopt when they tell you what the law is on a certain question. It's the sense of law that the president uses when he asks his advisors, is our treatment of the prisoners in Guantanamo Bay legal under international law? In this sense, which I've called the doctrinal sense of law, the question is not, would it be useful in some way to classify international law as law? That's a different question. The doctrinal question is, how do we decide what international law actually requires on some issue? That's the question that, though Hart did not attempt to answer, many of his disciples have attempted to answer. And a theory has developed of the ground of international law in recent decades, actually it's older than that, which claims that the ground of international law, understood in the doctrinal sense, is the consent of sovereign nations. How do we tell whether something is a rule of law? We ask, have the nations, the subjects of international law, actually consented to that being law for them? This view that consent is the basis of all international law, and therefore the basis of interpretation when we come to the difficult issues I described, was apparently codified in the statutes of the International Court of Justice. Every textbook, in thinking about this issue, I've read a number of textbooks on international law, and they all answer the question, what are the grounds of law, by pointing to the following paragraphs in the statutes of the International Court of Justice. Article 38.1, if you don't mind, I'll read it to you. The court whose function is to decide in accordance with international law shall apply 1. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. 2. International custom as evidence of a general practice accepted as law. 3. The general principles of law recognized by civilized nations. And then they add a 4th one, rather comforting to people in this building, which says, subject to the provisions of Article 58, the teachings of the most highly qualified professors of law at distinguished university. Don't be excited by that. It actually doesn't count for anything any more than any law review article any place would count. Now, Article 38.1 says the basis is consent. And that's a very appealing idea for many reasons. One of them is that it makes, a great positivist dream, it makes what is the law just a matter of fact. You find out what if states consented to. It also seems to preserve the idea of basic sovereignty of states. International law is consistent with the purest kind of sovereignty, because international law is just what states have consented to in the exercise of their sovereignty. It also resonates, incidentally, with a very important strain of political theory called social contract law. People say the basis of the legitimacy of government must lie in a social contract to which all people have agreed, or might have agreed, or under some circumstances would have agreed, something of that sort. And the consent theory says that's also true at the international level. There are, however, weaknesses, some of them apparent, in this idea that international law rests on consent. One of the weaknesses is, I read you out a list of the standards proposed in Article 38.1 of the statutes. No priority is given among these, no idea of what happens when they conflict. Also, you will recall from what I said that the statute doesn't really say that every state's consent is necessary. The statute says civilized nations must have consented, but it doesn't tell us who they are. It tells us about customary practice among nations, but it doesn't say every nation who is bound by the customary practice must have consented. And that's perfectly understandable, because international law that really applied only to those who have consented to it would not be very helpful. However, it does undermine the idea that consent is really consistent with sovereignty. I'm going to set those familiar objections aside this evening, however, because I want to concentrate on a more basic difficulty in the consent theory, a difficulty that points the way, in my view, to a better theory about the grounds of international law. The consent theory seems at every stage of its application to be fatally circular. Consider the idea that states make law by customary practice. 38.1 is explicit that it isn't just any old custom, any old usual style of behavior by a state that gets that state obliged by law. It's only, according to the international law doctrine, it's only custom established as if through recognition of law. The technical term is opinio juris. A state does not commit itself as a matter of law unless its behavior shows not just that it follows a certain practice, but that it follows a certain practice because it supposes that practice required by law. But then, if that's so, the state must, of course, have a different theory of the grounds of international law. It must have decided when it's bound by law or not. It can't use the standard of consent, because then it would be saying, in order to decide whether we've consented, we have to see whether we've consented. You might say, well, a state is bound as a matter of legal acknowledgement when it recognizes that other states have consented to be bound. But that doesn't break out of the circle. It simply means that we then have to ask what theory of law those other states were adopting when they decided that they were bound as a matter of law. Well, you might say, well, it's just a convention. But conventions are not automatically law. The existence of a convention can be destroyed simply when one party to the convention decides no longer to accept it. So, in fact, the consent theory cannot explain customary law. Once you accept that customary law means behavior governed by some other more fundamental standard of what the law is. What about treaties? You would think that treaties are a perfect example of consent, nations being bound because they have consented. It won't do. We personify states. We say states who have signed a treaty have promised and they must keep their promise. But it isn't the personified legal abstraction that's actually bound. It's the population. And that population probably is entirely different from the population whose leaders signed the treaty. There might have been constitutional changes so dramatic that none of the domestic law of that state has survived. Why does the obligation of treaty survive? Even if we hold fast to the personification and say the state itself has promised, we simply raise the question, a philosophical puzzle ever since Hume identified it: why does promising create obligations? Philosophers assume that there must be some deeper, some other principle of morality that explains why promising creates obligations. You cannot simply say that speaking magic words creates an obligation. There must be some explanation why. International lawyers might say to you, there is a deeper principle. It's called pacta sunt servanda. Very grand. When international lawyers speak Latin, you know that further unpacking is necessary. But pacta sunt servanda simply repeats that treaties impose obligations. It doesn't explain why they do. Now, I believe that we must start again. The consent theory, with its roots in legal positivism, its roots in absolute sovereignty of nations theory, must be set aside. We have to begin again. And I suggest that we begin again by going back to the spirit that animated the architecture of international law in its first golden age, 16th and 17th century, that we followed the lead of architects like Hugo Grotius, who began by saying, just assuming that international law was an aspect of international morality. As soon as one says that, then of course the question arises, well, how do we tell the difference then? If we start by saying international law is part of morality, we look to morality for the grounds, then we face the immediate question, what is the difference between decency and morality among nations, which is of course a moral matter, and international law, which is, if you say, also a moral matter, cries out for a distinction. Am I suggesting to you that there's no difference between what the law is internationally speaking and what it ought to be? No. The question of what international law is in my view, a moral question, but it's a distinct moral question. In other work, and particularly in the book that Marcelo mentioned, Justice for Hedgehog, that we're going to discuss tomorrow, I argue that we distinguish law from other parts of morality by identifying law as the set of rights that people are entitled to enforce on demand without the action of any other political institution, are entitled to demand from a coercive institution like a court. And so when we're thinking about what the law is, we ask ourselves the question, which rights or duties are appropriately enforced in that very special way on demand of individual people? Hard to apply that to international law, I agree, because there is no such institution as a general court with powers to enforce and jurisdiction over all states. It doesn't yet exist. We can solve that problem very quickly. We simply imagine such a court. We ask the question, if there were such a court, what would it be appropriate for a court to enforce on demand without further international agreement or legislation, simply on the demand of a single party? That is where we start. And then we start to answer that question, and I believe we start by concentrating on questions of political legitimacy. All across the planet, there are people with power, guns and armies at their disposal. Some of them, indeed most of them, claim moral authority to govern. They are not just terrorists, they're not just people with guns, they are legitimate rulers in some territory. What conditions must be met in order that a government be legitimate, that it have earned the title it claims? Very complicated matter, many books written on it. It comes down to three requirements. The power must have been formed. The state must exist properly. We are interested in the formation of a government historically. It's a very complicated question, which I won't touch on. When a state that was formed illegally by conquest, as North America and South America were, when a state, through some historic statute of limitations, becomes properly formed, that's an important question. But let us say that the formation of a state is one condition of its legitimacy. The second condition is not how it acquired power, but how it exercises that power. A legitimate government must rule democratically according to some proper sense of democracy, and it must respect the basic human rights of its inhabitants. That's again very vague and general, but it states a condition of legitimacy. I want to concentrate now on the third condition of legitimacy. That is, the international system which gives a particular state power and limits that power. The international system must itself be legitimate in order for any state whose power is secured by the international system of states. And that makes international law directly relevant to the legitimacy of all the members, one by one, of the international community. The Westphalian system, as we call it, of individual states with particular territorial boundaries, was formed 16th and 17th century as a way out of the horrors of the wars of religion which had torn the continent of Europe apart. But the Westphalian system, recognizing existing boundaries, has had and has many defects. The boundaries that are established under the present international understanding are arbitrary. They depend on where rivers run and who slept in which king's bed. They leave states vulnerable, and they have the system which awards territorial sovereignty on the basis of these historical accidents and protects states from interference by other states. The system, we might call it, of immunities has at least 4 grave defects that are stains on its legitimacy. First, it does not allow people in nations around the world to come to the rescue of fellow human beings who are terrorized by their own governments. Conversely, it allows states to terrorize their own citizens. Those are important defects in legitimacy. There are others. The international system prevents the nations from achieving any kind of coordination. We normally solve, thank you. Here is my suggestion for remedies to these problems. My suggestion is that states, out of a duty to protect their own legitimacy, have a further duty to mitigate the defects of the world system of nations. They have a duty to adopt practices that might bring about an improvement. That's a simple, straightforward duty, and it's a duty out of concern for their own moral title to govern. That is the underlying ground of international law. But by itself, it doesn't say much, because it doesn't tell states which of any number of practices they should adopt, any of which would be helpful if adopted by all states, but it doesn't tell us where to begin. I therefore recommend, in addition to the duty to mitigate, a different duty, which is a duty of salience, a principle of salience. And that is to say, if some rule or practice is made pertinent by history or practice, then states have a duty to join that rule or that practice or that principle as law. They have a duty to mitigate and a duty to do it in a way that focuses on salient principles, provided, of course, that the principle that is said to be salient, say the laws of war, provided that the salient principle is one such that if all nations did adopt it as law, then the legitimacy of the international system would be significantly improved. Where does salience come from? Oh. Where does salience come from? In the great golden age, salience came from two sources. International law was European, and Europe was Christian. And it was just accepted that the basic principles of natural law were also principles of international law. Europe also enjoyed what the Romans called jus gentium, that is, the principles that were common and shared among nations generally. We don't have a world understood to be Christian, and we don't have a world. The world has grown much larger. It includes not just old European civil law or common law system. It includes many different kinds of systems. We do not have a jus gentium. We need a different source of salience, a different beam of light around which nations may collect and acquit their duty to mitigate. We need that, and the world provided it in 1945 in San Francisco. We should think of the United Nations not as a big treaty binding on the nations that signed it or that later joined it. We should think of the United Nations as an engine of salience. It is obvious that the structure of the United Nations should be used to fill this need for collective action and the duty to mitigate. I think I shouldn't take much more of your time, but I do want to illustrate this by going back to the question of interpretation that I said was so important. Does Article 2.4 prevent intervention to stop genocide whenever one or two members of the Security Council veto an attempted intervention? There is a great disagreement among international lawyers about the powers of the General Assembly, which is not, of course, crippled by a veto. Would the United Nations have the authority, have the title to adopt a resolution empowering intervention to stop genocide? Consider, if I can find it, consider a resolution adopted, it's often called the Atchison Resolution, adopted in the United Nations at a time when Russia was boycotting it. Resolved, the General Assembly resolves that if the Security Council, because of lack of unanimity, fails to exercise its primary responsibility, then the General Assembly can do so. I believe that the structure of international law that I've described, the structure that says international law is a response to a duty to cure the illegitimate aspects of the international system, provides a very good argument that the General Assembly does have that power. I would myself, if drafting a resolution on behalf of the General Assembly, adopt a more limited version of the Atchison resolution, more limited in two ways. I would restrict the intervention to cases in which Article 2.4 does not plainly apply, that is, seeking a shift away from genocide rather than changing territorial boundaries. And I would also say that any General Assembly resolution licensing intervention would have to be submitted to the International Court. The General Assembly has the power to do that, would have to be submitted as a question to the International Court, and the question should be, is the target government guilty of crimes against humanity as defined in the Treaty of Rome establishing the International Criminal Court. I'm not suggesting that I can draft a resolution here and now, but that would be the main body of it. Would it be ultra vires, the General Assembly, to do that? That's a question of interpretation. If you adopted the positivist consent theory, undoubtedly not. If you adopt the theory that I am recommending now, I believe, yes. There are other suggestions that we might think of. If you want something even more extreme, I believe the General Assembly should adopt a resolution, which resolution would provide that a climate change regime could be enforced against all nations. Its allocation of emissions privilege could be enforced against all nations, provided that the scheme had collected what I would call a four majorities regime. That is, a majority of votes at the General Assembly, the votes of countries in the General Assembly collectively representing most of the people on the planet, a majority of members of the Security Council, a majority of members of the permanent members of the Security Council. I think if that's a very high hurdle, I think that if some hurdle of that character was adopted, there could be no objection made to it on grounds of world democracy, and it would, in my opinion, be within the power of the General Assembly, given the difficulties that the veto has posed in the Security Council. Now, you've been very patient as I have gone from one extravagant idea to another, and nobody has jumped up yet and said, but who would accept that? Very important question. The time may very well come when the need for international law more robust than we have it is apparent to all nations. My money would be on climate change as bringing that about. It may be, indeed, of course it is, that few nations would accept the theory of international law and the hypotheses about the powers of the General Assembly that I unveil. But, to repeat, we don't have a theory of international law. the consent theory is not an adequate theory. It's a failed theory. When and if the time comes when the nations of the world are ready for a better theory, it shouldn't be our fault. It shouldn't be the fault of the academy. It shouldn't be the fault of the law schools that we aren't ready with one. So we should debate. And if you think mine is a bit extravagant, then the question would be, can we have any theory, given that the consent theory won't do? And it falls on the profession, and particularly on international lawyers, to return to the old question, is there any such thing as international law? And on the assumption that there is, what are its grounds and what are the interpretive implications of those grounds? We have been for too long cataloging the boughs and the twigs of international doctrine. Now it's time to nourish the roots. Thank you.